You hurt yourself at work, became disabled, and then began receiving workers' compensation. You saw an employer doctor, and soon after that you received a letter to go back to work to a modified job within your restrictions. You don't think you can do it, and your doctor agrees with you. What should you do? Let's talk about it. Hi, I'm Larry DeMarco, and I'm a Pennsylvania workers' compensation, personal injury, and family law lawyer. This scenario plays out in court throughout the Commonwealth of Pennsylvania all the time. No one should go through this situation without a lawyer giving you legal advice. The consequences of these choices can make or break the entire claim. So you need as much information and advice as you can get. There's no way you should make this decision without being fully informed of your legal rights and being counseled through the process. Here's what I've seen dozens of times over my career in my practice. The scenario that plays out in court can be like a competition or a game. And the factor that determines who wins is the party who acted in good faith throughout the process and more reasonable in the eyes of the judge. So let's look at this from the perspective of the employer and ask, what do we as a society expect from an employer in this situation? We want an employer to make every effort to return the employee back to work within his or her medical restrictions so that he or she again can earn a good living. In contrast, we don't want the employer to act in bad faith just to stop the payment of compensation. Someone who sets the claimant up just to fail in any way so the employer can win. That's bad faith. Now let's look at this from the perspective of the injured worker. What do we want our injured workers to do after they're hurt? We want them to make every effort to return to work and again become a productive member of society. An injured worker acting in bad faith just wants to stay home and collect the checks and have them continue at all costs, including refusing good faith offers for employment. So now let's return to the original scenario at the beginning of the video. The conflict is that the worker is referred to a job that he or she doesn't think they can do, but the employer is a doctor who cleared the claimant to return. The treating doctor is almost always on the patient's side and supports the injured worker and the symptoms. In workers' compensation court, so going back, let's assume that the worker refuses the job. In court, the judge decides whose doctor is more credible. If the judge believes the employer's doctor, then the worker's benefits are reduced or suspended in proportion to the wages that the claimant would have received if he or she went back. If the judge believes the claimant's doctor, then everything stays the same and the checks continue. The injured worker is in a vulnerable, scary position during this battle of the experts. In my experience, when the worker finds him or herself in this position of uncertainty, it's a losing proposition. Giving up your control by just allowing the judge to decide the winner by choosing what doctor he or she likes better should be avoided at all costs. The injured worker who had the best success were the ones who made every effort to return to even positions that seemed beyond the restrictions of their own treating doctor. It's completely counterintuitive to do this and sometimes could take a Herculean effort to pull off, but it almost has always worked out. One or two things can happen when the claimant pushes him or herself beyond the medical restrictions from his or her own doctor. Number one, the employer accommodates the injured worker and doesn't push too hard. The worker is able to function in the job long enough to continue to earn a living until he or she heals or until a favorable settlement is gained. Workers' comp benefits will be reduced when the person goes to work, but he or she won't have a wage loss, is at no risk, never loses income, and doesn't need a judge to protect him or her. The other way this can play out is if the worker is not able to do the job, tries, but then has to leave the job, and then might need to receive continuing treatment for any increased problems. After a legitimate good faith effort to complete the worker goes to court and gives detailed testimony describing the effort and all the attempts to do the job And when the judge hears it, most frequently, the judge appreciates the attempt and gives the worker every benefit of the doubt for trying. The results have been much better, whether a favorable decision or a higher settlement. To conclude, my experience has demonstrated that it's a much safer choice and much wiser financial decision for an injured worker to make a good faith effort to return to work, even when exceeding your own doctor's restrictions. If you can't continue because the job is too hard, keep seeing your doctor during these attempts and during the days that you miss from work so the doctor can be a well-informed expert witness on how it all went down. Don't do anything without keeping your lawyer in the loop and following counsel's legal advice. I hope you found this informative. Please check out other legal videos on my YouTube channel. Thanks for watching. If you or someone you love has been injured or suffered a loss, contact the Law Center. For more information, click the link in the description portion of this video.